Hello, I'm George from Ireland. Back to English law and the liability of public bodies. So looking at various public policy considerations for limiting liability. There's immunity and negligence about what the police do when they're investigating and trying to criminals and trying to apprehend criminals. But this is occasionally displaced by other public policy reasons. In Sinney against the Chief Constable of Northumbria in 1997, the claimant had given information to the police about a major felony and had therefore been subject to threats of heavy violence and indeed having his house burnt down. And the defendant negligently allowed the woman's name as a police informant to come to the notice of criminals. So this woman then, she took legal action against the police in negligence on the ground that they'd been under duty of care to keep her name secret. The defence sought to have the case struck out by saying that on the basis of Hill, it had disclosed no cause of action. But the Court of Appeal found that this required foreseeability and proximity. So when it came to the policy stage of this, the claimant was found to have at least an arguable case on the ground of public policy because the fight against crime relies on information supplied to the police by members of the public, Bartons. So despite Hill, the plaintiff had an arguable case in negligence, and there was enough proximity that she was not merely a random member of the public, but she already had a special relationship with the police, and therefore she was distinguishable from Joe Public because of the reliance on her information. And as the case went to trial, it was found that police, in leaving the information in a locked briefcase and locked car, had not been negligent. Nonetheless, criminals had got access to it by breaking into a locked car, by breaking into a locked briefcase. It had been not unreasonable to leave the info in the briefcase. Though there was a duty of care, there had been no breach of the same. So how about in an education or social work setting? The House of Lords have had to judge lots of cases about social workers and education. And they were reported together as X against Bedfordshire County Council in 1995. Some of the cases were about failures of educational psychologists to correctly diagnose conditions such as dyslexia. The House found that these claims should not be struck out. There were two cases about social services. A Bedfordshire case. Social services had not taken children into care, despite numerous reports from teachers, neighbours and others that they were being seriously abused. In another one, the Newham case, the social workers took a child away from her mother into care because they got confused about two men who had the same name and thought she's being might be molested by her mother's boyfriend. But the molester was a different man who happened to have the same name as the boyfriend. The House said there was no duty of care in either case. The cases were then taken to the European Court of Human Rights in Strasbourg. So as well as their claim in common law negligence, the children brought an action for breach of statutory duty, saying that the injury came from breaches of the Children Act 1989 by the local authority. And the Lords had found, in the light of the range of remedies under the Act, there was a statutory appeals procedure in the education cases, that it was not conceivable that Parliament wanted to be an extra right of action for breach of statutory duty. The tortious duty of care is not in concert with these remedies, and therefore would wreck this very complicated statutory framework about educational bodies, physicians, the police and so on, that had been specifically created by Parliament to protect children. In the Bedfordshire case, the court found that there was a breach by the United Kingdom of Article 3 of the ECHR. Authorities had not saved children from inhuman treatment. There's Z against UK in 2001. In the Newham case, the European Court, so there was a breach of Article 8. The mother had not had access to documents which would have shown the confusion. TP and KM against the United Kingdom 2001. Later on, the House of Lords found that the council was vicariously liable for failure of these educational psychologists whom it was working for it. Phelps against Hillingdon London Borough Council 2001. The employee was exercising a statutory function and was providing a service like any other professional. The decision was grounded on the fact that educational psychology is there particularly to advise and assess for the education of a child. And it's obvious that parents and teachers are going to go along with that advice. The educational psychologists therefore have a duty of care to the pupils, and this is what Lord Slynn said. The phrase can be misleading in that it can suggest that a professional person must knowingly and deliberately accept the duty of care. The phrase simply means that the law recognises that there is a duty of care. It's not so much the responsibility is assumed as it's recognised or imposed by law. So there have been lots of other social work cases. In one of them, the Court of Appeal found that to comply with the rulings of the European Court of Human Rights, you need to follow Z against the UK rather than X against Bedfordshire, and found that duty was owed to the child, but was not owed to the parents suspected of abuse, because the interests might conflict with those of the children, so therefore whose interests are to prevail, in which case we say there are no parental interests. There was an appeal to the House of Lords by the parents. The House found that there was no such duty. That's JD against East Berkshire Community Health NHS Trust, 2005. Okay, how about failing to exercise a power that you have? The usual principle is that failing to exercise a power is an omission, and there's no liability for that. But the trouble here, well, it had to be considered in Stoven against Wise 1906, and a majority found in the appellate court that the council's failure to exercise its powers to remove an obstruction from private land which intervened with a motorist's view at a dangerous junction would not give rise to liability. And this was considered and qualified in Goring against Calderdale Metropolitan Borough Council in 2004. It went to the House of Lords. Now, there are certain qualifications. A council can bring itself under an obligation to exercise its powers to deal with a potential peril on the road where its own actions have created the danger, such as Kane against New Forest District Council 2001 or Yetkin against Mahmood 2010. All right, so there's liability in some particular circumstances. There are situations where a duty is held not only to have aggravated a situation, where the local council would have done nothing. You see, there's Capital and Counties plc against Hampshire County Council 97, about the fire service, and Kent and Griffiths 2000. That was about ambulances. So in Capital and Counties, there were lots of appeals that were brought together and heard all these claims of negligence against the fire brigade. The fire officer at a scene of a fire had ordered a sprinkler system in a burning building to be turned off. If the sprinkler had not been turned off, the damage created by the fire would be far less severe. The liability was because of the action of the fire officer, which had aggravated the claimant's position. In the second situation, the fire brigade had gone to the fire and left the scene, and they thought they'd extinguished the fire. However, they hadn't, and then the fire began to rage once again, and therefore it created more harm. The third case was about the fire service not inspecting and maintaining fire hydrants properly, and not ensuring that there was an adequate supply of water in the case of a fire. The Court of Appeal said there was no proximity of relationship between the fire brigade and the owner of the building in regard to negligence about putting out the fire. So policy considerations were about, because then there could be defensive firefighting, as in just unduly vigilant and excessive zeal in putting out fires, which makes it more costly, and then they can't go to another fire. So liability in negligence in the tackling of fire would not arise because the fire service negligently increased the, unless they negligently increased the damage or that they caused extra damage. So in Kent and Griffiths, it was an emergency situation. A doctor called an ambulance service and said that an ambulance had to come to a pregnant patient's home urgently. Even though he called several more times, the ambulance didn't arrive till 38 minutes after the call. Although the claimant had been given oxygen on the way to the hospital, she suffered a respiratory arrest and then brain damage was sustained in a miscarriage. The Court of Appeal found that in some circumstances an ambulance service could be liable for negligence, but no duty is owed to the general public to respond to a call for help. After there's been a 999 call in a serious emergency been accepted, the ambulance service did have an obligation to provide the service for a particular individual at a certain address. Okay, so there can be this general duty of care of civilian receptionists in hospitals. Remember Darnley against Croydon Health Services NHS Trust Limited.